Before I go over this section, I'm going to explain two things. The first thing is the infant compromise order, and the second thing is CPLR 3017. So the infant compromise order is when a infant or incompetent or conservatee is going to settle a claim that they have. It has to be approved by the court. So I'll tell a quick story about this so you'll understand. When I worked in district court, there was a settlement attempt by an attorney who represented a mother and a child, and the child had been in a car accident, and the attorney was trying to settle with the insurance company for $5,000. And it turns out the judge refused to allow the settlement because they had never even brought the kid to a neurologist and there was a head injury alleged. So when the judge had the in-camera with her, she talked about getting headaches and everything, and the judge would not approve the settlement because basically once you accept a settlement, that's it. You can't turn around and realize that the kid had like problems and then try to get more money from the insurance company. So when 202.21 is talking about an approval of the settlement of a claim of an infant, incompetent, or conservatee, that's what they're talking about. They're talking about there's only one side who's filed a petition for court approval of an out-of-court settlement. That's the first thing I'm explaining. The second thing I'm explaining so that you'll understand this rule is CPLR 3017. CPLR 3017 describes pleadings, and generally when you make a pleading, a complaint is a pleading. So in the complaint, you have to allege the amount of money you're suing for. So if you're suing for typical tort cause of action, you have to say, I'm suing for $1 million. But for certain types of actions, including medical malpractice, you cannot allege a monetary amount in the pleading. You simply say, this claim exceeds all lower courts' jurisdiction, and that's why I'm filing in the Supreme Court. So just keep those two things in mind, and now I'm going to do this rule. A, general. No action or special proceeding shall be deemed ready for trial or inquest unless there is a note of issue accompanied by a certificate of readiness with proof of service on all parties entitled to notice in the form prescribed by this section. Filing of a note of issue and certificate of readiness is not required for an application for court approval of the settlement of the claim of an infant, incompetent, or conservatee. Okay, so where's your exception? When do you not have to file a note of issue? And the answer is only for court approval of the settlement of the claim of an infant, incompetent, or conservatee. The note of issue shall include the following: index, name of judge, name, office address, and phone number of each lawyer who has appeared, and name, address, and phone number of each party who has appeared pro se. So it's still a little bit different. You have to have pro se parties have to have their name, phone number, and address. And the name of any insurance carrier acting on behalf of any party. Now pay attention, this next sentence is one that you must commit to memory. Within 10 days after service, the original note of issue and the certificate of readiness, where required, with proof of service where required, shall be filed in duplicate with the county clerk together with payment of the calendar fee or a copy of a poor person order. And a duplicate original with proof of service shall be filed with the clerk of the trial court. The county clerk shall forward one of the duplicate originals of the note of issue to the clerk of the trial court stamped fee paid or poor person order. So basically what this means is that after you serve your note of issue and certificate of readiness, you have 10 days to get 2 originals of the note of issue and proof of service. You take them both to 8811 Supton Boulevard, to the county clerk, you pay your fee, and you hand them both duplicate originals and proof of service. And then the county clerk forwards one of the duplicate originals with a stamp on it, either saying fee paid or poor person order. And then it says B forms, the note of issue and certificate of readiness shall read substantially as follows. And then here it is. Index number, name of assigned judge, trial by jury requested, all this information on here, amount demanded. Okay, so notice that, insurance carrier of known, and then it says, note, the clerk shall not accept this note of issue unless it's accompanied by certificate of readiness. So then here's the certificate of readiness. It's actually attached right to the note of issue, so you can't forget about it. This is where the discovery comes in, medical reports exchange. You have to check where, if it's completed, waived, or not required. Compliance with section 202.16 in matrimonial actions. So if you're having a non-matrimonial action, you're just suing somebody for a, breach of contract or something, you're going to check not required. Discovery now known to be completed. Necessary discovery completed. There are no outstanding requests for discovery. Reasonable opportunity. Medical malpractice actions have special things, and then you have to certify the case is ready for trial. Signature, attorney's office address, etc. C. Jury trials. A jury trial may be demanded as provided by CPLR 4102. Where a jury trial has been demanded, the action or special proceeding shall be scheduled for jury trial upon payment of the fee by the party filing the demand. So if you file a demand for a jury trial with your note of issue, you would pay the jury fee. You would check this box, jury trial demanded, specific issues, all issues, whatever. You would check this box and you would pay for the jury demand at the time that you're filing the note of issue. If you get a note of issue served on you and there's no jury demand, you can actually demand the jury yourself. You can file a jury demand and pay the fee, and you have 15 days to do that. If no demand for a jury trial is made, it shall constitute a waiver by all parties, and the action or special proceeding shall be scheduled for non-jury trial. D. Pretrial proceedings, where a party is prevented from filing a note of issue and certificate of readiness because the pretrial proceeding has not been completed for any reason beyond control of the party, the court, upon motion supported by affidavit, may permit the party to file a note of issue upon such conditions as the court deems appropriate. Where unusual or unanticipated circumstances develop subsequent to the filing of the note of issue, which require additional pretrial proceedings to prevent substantial prejudice, the court, upon motion supported by affidavit, may grant permission to conduct the necessary proceedings. So there's two exceptions to the rule that discovery always has to be completed, and they are right here. One is that the party, through no fault of their own, is unable to file a note of issue and certificate of readiness because a pretrial proceeding has not been completed. So let's say they have one more deposition to do, but they're like, after this, we really are done. We really want to get in line on the trial calendar. We really want to get in line. What is that? Oh, okay. So, Your Honor, here's my motion supported by affidavit, and motion is an application for an order supported by affidavit and get an order allowing you to file the note of issue and certificate of readiness, even though there's still an outstanding deposition to be done. The other thing is this exception, where unusual or unanticipated circumstances develop after the note of issue filed. So you already got online to get a trial. So you're on the line for the trial calendar because your note of issue was already filed. Then it turns out you find out something, you need to take another deposition or something like that. You can make a motion to the court supported by affidavit alleging unusual or unanticipated circumstances have developed, and if not allowed to do discovery, there will be substantial prejudice. That's the standard. E. Vacating note of issue. Within 20 days after service of a note of issue, any party to an action or special proceeding may move to vacate the note of issue upon affidavit showing that the case is not ready for trial, and the court may vacate the note of issue if it appears that a material fact in the certificate of readiness is incorrect, or that it fails to comply with the requirements of this section in some material respect. However, the 20-day time limit shall not apply to tax assessment review proceedings. After such period, except in a tax review proceeding, no motion shall be allowed except for good cause. At any time, the court, sua sponte, may vacate a note of issue if it appears that a material fact in the certificate of readiness is incorrect or that it fails to comply with requirements in this section in some material respect. If the motion is granted, a copy of the order vacating the note of issue shall be served upon the clerk of the trial court. F. Reinstatement of note of issue. Motions to reinstate shall be supported by proper and sufficient certificate of readiness and by an affidavit by a person having first-hand knowledge showing there is merit to the action, satisfactorily showing the reasons for acts or omissions which led to the note of issue being vacated, stating meritorious reasons for its reinstatement, showing the case is presently ready for trial. So if you kind of blew it the first time with your note of issue and the other side made a motion and they won and now it's been vacated, you have to do this other procedure to get it back on the trial calendar. You have to have an affidavit by a person having first-hand knowledge showing there's merit to the action, why it was vacated in the first place, and meritorious reasons for reinstatement and showing the case is ready for trial. G. Limited specification of damages demanded in certain actions. This section applies only in counties where the fucking chief administrator established an arbitration procedure. So in most counties downstate, there's mandatory arbitration. And now remember that rule in 3017 I was talking about where you have to say the amount demanded, if any? Well, sometimes you're not allowed to. Like in a medical malpractice, you're prohibited from saying how much money you want. Okay, so you said no amount in the pleadings except that it exceeds the jurisdiction of all lower courts. Now you also have to say it exceeds $6,000. If for some reason you're suing in Supreme Court and you've decided that your lawsuit does not exceed $2,000, then you would also say that. For some reason it was under $6,000 but more than $2,000, you would have to put that in the note of issue. And that's so that they can send you to mandatory arbitration. H. Change in title of action. In the event of a change in the title of the action by reason of a substitution of a party, no new note of issue will be required. Notice of such substitution and change in title shall be given to the assigned judge and to the clerk within 10 days of the date of an order or stipulation affecting the party substitution or title change. I. Additional requirements for uncontested matrimonials. 1. Uncontested matrimonials shall be assigned to judges or special parts as the fucking chief administrator authorizes. 2. There has to be a certified court system uncontested divorce packet that contains official forms. The package shall be available in the office of the clerk of the Supreme Court in each county. So not in the county clerk's office. They're in the Supreme Court clerk's office. And the form shall be filed with the appropriate clerk in accordance with the instructions in the packet. These forms shall be accepted by the court for getting an uncontested divorce and no other form shall be necessary. The court may allow other forms that comply with the requirements to be accepted, but whatever's in that packet, that's all you need for an uncontested divorce. 3. The proposed judgments shall be numbered in the order in which they are received and submitted in sequence to the judge or referee, signed in the order they are submitted. 4. Unless the court orders otherwise, the proof required by statute must be in writing by affidavit, which shall include a sufficient factual statement to establish jurisdiction, as well as all elements of the cause of action warranting the relief sought. Don't think they'll make a question out of that, but here we go. 5. If the judge or referee believes the papers are insufficient, the complaint shall either be dismissed for failure of proof or hearing shall be directed to determine whether sufficient evidence exists to support the cause of action. 6. Whether upon written proof or after a hearing, the judge or referee shall render a decision and sign the findings of fact, conclusion of law, and the judgment, unless for reasons stated on the record, decision is reserved. 7. Where a hearing is held, no transcript shall be required as a condition precedent to the signing of the judgment unless the judge requires it. So basically, if there's a hearing in an uncontested matrimonial, you don't have to order the minutes unless the judge or referee presiding directs it.